Welcome to the bold analysis, ladies and gentlemen. And I am still in Kisumu. I want to do a very good shout out to Eric Onyango. Yes, one of our subscribers here. Thank you for the warm welcome. Kisumu has been an amazing place for me. We followed the petition by Azimio la Umoja lawyers, and their submissions really took the time. They were given the time to make their submissions. So that was today. Tomorrow, the court is going to listen to submissions on the William Ruto and I think IBC lawyers side. And if you followed, you realize that I think they organized themselves that each and every lawyer was having a specific line of defense, or rather the line of submission. And you could hear the way, you could just find out the way that was organized, because James Orengo started off by explaining why, convincing the court that William Ruto did not get the 50% plus one vote that is needed for him to be legitimately named the president-elect. Now, apart from that, something that happened, IT experts, after IBC after Supreme Court ordered the IBC to allow the Azimio experts to access the servers, there was a push and pull between the IT experts on Azimio and IBC experts into what extent of which servers they could access. Actually, it emerged that the servers were 8 and ABC had only allowed 1. Even though somewhere 6 p.m. there was another story that came out that IBC had allowed all of them, had allowed the Azimio team to access all the 8 servers that were being used. But something interesting came out from that, because Paul Mwangi, who was representing the Azimio, was insisting that there is nothing that has been going on, or there is no progress that has been done so far. But again, something was very interesting, that IBC experts were actually saying that they could not allow the Azimio to access everything, because some of them, if in any case there's going to be a rerun, those servers are going to be reused, and of course there will be breach of what is supposed to be received there. Now, I want us to look at the submission by Murgor. Philip Murgor is the lawyer that made a presentation on how the Form 34A were intercepted from the polling station to intermediate to a middle server. Then from the middle server, the editing was done there according to his submission, then re-uploaded to the portal and also the Constituency Tallying Center. Now, I listened to that presentation, and of course it was in coherence with what we had actually analyzed from the petition. But I took keen interest on the Njoki Ndung'u posts. Njoki Ndung'u, who is one of the Supreme Court judges, asked the lawyers to explain on how, if editing is done, can editing be done on a handwritten Form 34A? In that, a presiding officer wrote the results in Form 34A with his handwriting, but then at the portal they were edited. The IT experts should help us just explain, because also that one really took my attention. Can it be edited, and if how? But then it cannot be adding a number. People have thought of they take that figure and add a number. If you add a number, the change is huge. For example, if Raila have for 115 in a polling station and William Ruto have 417, you cannot add 0 in that one for Ruto, because if you add it will be 4,000. There is no polling station that have more than 4,000. There is no polling station that have more than 4,000, because each polling station must have 700. So, and of course there is no polling station and someone has got to serve 4,000. Now, the only possibility is what I can say as trying to manipulate the figure. If 1 can change to 7, and maybe 6 can become 8, or 5 can be 8, or 1 can be 9. Perhaps we'll try to look at it that way. But again, it requires a meticulous approach, because at the end of the day, the numbers should always must balance. So this will be above board if someone is going to prove it. But then I'm not an IT expert, so someone can help us now. This is the point where Murgor was explaining about the form was uploaded as JPEG, but it arrived at the portal as a PDF. There will be need for Azimio to prove this claim by the physical forms that were collected by the agents. I think one of the Supreme Court judges tried to bring out clearly that the difference should be seen in the Form 34A at the polling station, and whatever was actually produced from the portal at the portal, which was what was manipulated. So this is part of it. It will form part of the disease. Now I want us to look at the other submission. The submission by Apollo Mboya, on behalf of the 4 commissioners. Apollo Mboya spoke about how the 4 commissioners was pushed to the periphery, and the court was shocked to understand. And by the way, it doesn't really make a lot of sense, where a commissioner was relegated to doing as a protocol officer, as ushering people in the VIP, and some of them, in charge of hospitality. It didn't really work, even though it can be perceived as a way of collective responsibility of just trying to divide the roles. But someone in the caliber of a commission, it doesn't really make sense. But then Mwilu and Kome wanted to seek clarification on the dysfunctionality of this commission. At what point did the 4 commissioners realize that they were being sidelined? And I remember Uko asking, why did this thing happen? And they never protested, even before that. Everything was fine at the verification process until the last moment. So if they could have been there, I'm really looking at how Azimio is going to respond to that, because it's equally very important. Now, the collective responsibility of the commission on Chebukati working closely. Paul Muitr was also representing the 4 commissioners, actually insisting that the commission work is a corporate entity. So in a corporate entity, above decisions are binding. There is nowhere in the constitution where Wafula Chebukati had veto powers above other commissioners. So they also tend to find out what exactly that is done. What is also interesting for me, I want us to look at this, is the constitutional frameworks. If Azimio, or rather the Azimio team wants Chebukati to be ejected from the commission, and that to me will be if and when they realize that, of course, he's directly liable for mishaps in the commission, or rather in the election process. Now the court is having an argument here that how can they eject Chebukati while there is a constitutional framework on removal of the chairman of Chebukati? Will someone go to court and term their order as constitutional and challenge their order in an inferior court, in a high court, saying that maybe the order they gave on that is unconstitutional because there is no framework that IBC, like Supreme Court, cannot propose because there is stipulated ways of removing Wafula Chebukati. So they want to find out whether can those orders be termed as constitutional. And more importantly, interesting is this, if we are to go for a rerun and the Azimio team wants Chebukati to be ejected from the process, who is going to take care, or who is going to stand in that rerun? Because we'll have a constitutional lacuna. can the deputy take on, number 2? But at the same time, you say that the decisions should be binding. So if decisions should be binding, then if Wafula Chebukati is to leave the commission, then everyone else, involving even the other 4 commissioners. So the court also wants to determine if they're to make that, can it be possible? Lastly, possibility of courts ordering a retally, recount, and declare Raila Odinga president-elect. Is it backed up by the constitution? And this will be interesting because I remember this conversation came on some earlier about what exactly the court was going to conduct, and the people came out to say that constitution allows the court to order recount, order retally, and award the legitimate winner, or order Wafula Chebukati, the chairman of the commission, to award that certificate to the legitimate winner. So Ibrahim, I think Supreme Court judge, is trying to ask whether constitutionally they're allowed, and in terms of recount or retally, do they have that threshold? Because the constitutional requirement is that they must give that verdict by Tuesday next week, 14 days. That means that, can they order recount? How long will it take? They lack that capacity, and also in the interest of time. So these are some of the things that are coming out from the courts. I will just doing a brief of what Azimio la Umoja presented and the questions from the judges. The Supreme Court, I think, might have to do more of arbitrator and just use a lot of wisdom, because any the decision seems to be, any the verdict seems to be throwing a country into some sort of a crisis. So let's look at that. Kindly, ladies and gentlemen, that's my bold. I want to finish up by asking you that we have 5 days to the end of Sarah Atieno's fundraiser. We did 15 days extension. So Sarah Atieno is one of our subscribers, and she's been suffering acute leukemia in Kenyatta Hospital. The members of this channel, we have been contributing, just supporting by doing a 50 shillings challenge, at least 50 shillings donation. And I want to say thank you deep from my heart that we've really turned up, we've really tried our best. And of course, I believe that we're on course. We've reached 160,000. This is not in vanity. This is still a big step. And I want to thank you guys for those who've been contributing and have been doing this. As we target the next 55,000, I believe that in the next 5 days, we'll be in a position to pull that. The next 5 days, so that on Tuesday, we can discharge Sarah from the hospital. You can contribute. My number is up there, 0710 62 78 89. Kevin Oduor Olo. Say to Lapia Kevin Olo. And may God bless you.